do you do? The light you plan to shatter. What do you say? The one you love is gone. How do you live? Seems like no hope for tomorrow. It doesn't care where you live or who you are. See, my life is broken. I don't know what to do. Yeah. When I can't see, I know. Whoa, when I cry out. Now I'm free. I know you hear. I'm praying for healing. Where do you call when no one has the answer? Where do you go? The place you've known is no more. When will they stop? All the tears, they just keep falling. Doesn't care. Pain doesn't care where you live or who you are. Don't know what to do. Count on you there. When I can't see, when I cry out, I know you feel. Now I'm praying, yes, praying for healing, yes. We ask you to forgive. The same love as we receive your love. Maybe it's time to hold on and wait just a little while. We're in the midnight. Come on. Just a little while, say, bring the song to sing. Oh, everybody put your hand together and say it. Hold on, say it, hold on, say it. Just a little while, say it. New York City, did you hear me? Greetings, 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 greetings. I am King Clifford Jefferson, ascendant and descendant of Godfrey V, Count of Anjou, son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceable, which is our Christ. It is April the 25th, 2026, which is equivalent to the Berber year 2976. I greet you in the name of my Queen, Sister Galveston, from the House of Galveston. I greet you in the name of our ancestors, our predecessors, our successors. I greet you in the name of the capacity that I operate in lieu of the interest that runs with that capacity in reference to the land, our inheritance, our lost estate. This is Trump, capacity and interest, Christ or the Antichrist? This is a question for you all to ask yourself. But secularism will decide. Okay? Once again, Trump, your current corporate body of politics entity, okay, who has a capacity and interest based upon what we call a legal or ancient term, which is called a retrospective term, known as prescription of sovereignty. Prospectively in law is now called eminent domain, which is the power of the Fifth Amendment. Okay? So this is going to be a beautiful lesson. Like, share, subscribe, as well as donate your free and common sockets, those who have the ability to do so, to the Clifford Clifford Jefferson L, or to the Third Temple English Church of England. This is all for you in regards to really trying to understand who you are as a people based upon your ties to this land, which is denotes to just sanguineous. Okay? All right? By way of your parents. All right? Very important because this is not a common law thing. It is not an inheritable thing. It is a legal fix that was created by a statutory law known as de notis ultima re, which is those children born beyond the seas. A 1350 Act that was created by our ancestors, King Edward III of the Plantagenet dynasty and the Plantagenet kingdom, which I am, through incorporation, the overseer or the acting party in that particular capacity, known as the corporate office, known in modern day as the corporation. So please hold on to your seats, brothers and sisters. This is going to be a good one. All right? We're going to look up the two terms, Christ and Antichrist. Okay? Let's define these two terms. All right? Very important. Once we look that up, we're going to look up the term secularism. Very important. Write these terms down. Christ and Antichrist. Within those terms, you did not hear once the name Jesus. All right? Very important. So let's look up Christ. Hold that thought for a minute. Christ, used by Christians and Muslims as both a name and a title, ambiguously refers to Jesus. You hear that? Ambiguously refers to Jesus. As a title, it is used both in reciprocal from Christ Jesus, meaning the Messiah Jesus, or Jesus the Christos, or Jesus the Anointed, and independently as the Christ. The earliest texts of the New Testament, the Pauline epistles, often refer to Jesus as Christ Jesus or simply Christ. When we refer to him here in the English church, it is Christ, not Jesus Christ, but it's King Edgar the Anointed or the Christ, the one you see here on my right side. Okay? He is King Edgar the Anointed, the Christ. This one on my left side is the person as Jesus assumed to be or presumed to be the Christ. Okay? But we're going to let secularism decide that. All right? Based upon the establishment clause. All right? The concept of Christ in Christianity originated from the concept of the Messiah in Judaism. Christians believe that Jesus is the Messiah foretold in the Hebrew Bible and the Christian Old Testament. Although the conception of the Messiah in each religion are similar, for the most part they are distinct from one another due to the split of the early Christianity and Judaism in the first century. This would particularly be around in our time 950 to 951 AD, Annos Dominios, meaning in the year of our Lord. Okay? Very important. Now let's just look up Antichrist. And this is simply from Wikipedia. In Christian eschatology, if I'm pronouncing that right, Antichrist, or in a broader eschatology, anti-Messiah, refers to the kind of entity prophesied by the Bible to oppose Jesus Christ, okay? Or what we say, Jesus Church, okay? We know when we're dealing with Christ or Jesus, it's synonymous with the church or religion or ecclesiastical or canon law, okay? Very important to understand that. So in Christian eschatology, Antichrist, or in its broader eschatology, anti-Messiah, refers to a kind of entity. When you say entity, you're not talking about a what? Natural person, okay? Or a private person, okay? You're not talking about that. You're talking about a person who holds an office, okay? An office. We call that term capacity. Okay? Everybody write that word down. Capacity. Okay? Without the capacity, you have no interest in whatever the Bible is talking about in reference to some person called Christ or Jesus. You must have the capacity. The capacity is the anointing. Okay? It is the anointing. All right? If you don't have the anointing, then you don't have the capacity. That makes you anti-Christ. Okay? Very, 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 very important. The term Antichrist, including one plural form, is found 4 times in the New Testament solely in the first and second epistle of John. Antichrist is announced as one who denies the Father and the Son. The similar term pseudo-Christ or false Christ is also found in the Gospels. In Matthew 24 and Mark chapter 13, Jesus alerts his disciples not to be deceived by the false prophets who will claim themselves to be the Christ, performing great signs and wonders. 3 other images often associated with the Antichrist are the little horn and Daniel's final vision, the man of sin. And in Paul the Apostle's second epistle in Thessalonians, the beast of the sea in the book of Revelation. This is very, very, very important. All right? Very important. All right? So we understand Christ and the Antichrist. Antichrist. We know Christ means anointed, which means Messiah, and the Messiah is based upon the church, God's church, Jesus' church. All right? Very, very important to understand that. All right? So if that is in fact the case, all right, we have to look to secularism, okay? Because this is the proof. What is secularism? Everyone look at the title of this lesson. Trump, capacity interest, Christ or Antichrist. Secularism will decide if Trump is the Christ or the Antichrist. Very important. Here's a message. Hold that thought. Secularism is the principle seeking to conduct human affairs based on naturalistic consideration, uninvolved with religion. Once again, we're talking about Trump, his capacity and interest in regards to whatever authority he claims to have in regards to uh, the corporate body of politics in which he oversees as the head executive officer. Okay? All right? And we understand that secularism, which is based upon secular laws for human beings, okay? Because secular has to do with the world. The church doesn't deal with secularism. It deals with ecclesiastical and canon law that's rooted in spiritual law. Okay? All right? Spiritual law. But that in itself has been or become secularized. Okay? Which is the key. All right? You're missing the key, which is the entry into a state of heaven consciously. All right? Secularism is the principle of seeking to conduct human affairs based on naturalistic consideration, uninvolved with religion. So if it's uninvolved with religion, then it's uninvolved with God. Okay? And Jesus or Christ or the Messiah or any other term, Isa, who else? Yeshua, had nothing to do with that. Okay? Because that is purely rooted in spiritualism. Okay? Very important. And most commonly thought of as a separation of religion from civil affairs in the state. It may be broadened to a similar position seeking to remove or to minimize the role of religion in any public sphere. Did you hear that? Okay? We're talking about capacity and interest in lieu of one, i.e., Donald Trump, being the Antichrist or Christ. Okay? We know Christ is the capacity. Okay? We know it's an office. Okay? Not a human office, but an office of an entity. Okay? Very important. So secularism is the principle of seeking to conduct human affairs based on a naturalistic consideration uninvolved with religion. It is the most commonly thought of as a separation of religion from civil affairs in the state and may be broadened to a similar position seeking to remove or to minimize the role of religion in any public sphere. Secularism may encapsulate anti-clericalism, atheism, agnosticism, naturalism, non-sectarianism, neutrality, or topics of religion or anti-religion. Although often conflated with opposition to religion, secularism is concerned with minimizing its role rather than disproving it, and may be either hostile, neutral, or hospitable to religion. When presented as a philosophy, secularism is another term for naturalism, nationalization, or nationalism, same word, seeking to interpret life based on principles derived solely from the material world and focus only on temporal material concerns. Once again, temporal material concerns. They're saying a whole lot. Most of you are not listening, so let's continue. Now let's look up the Establishment Clause. Write that down. In America, or in American law, or United States law, or state law, the Establishment Clause of the First Amendment to the United States Constitution, together with that of the American Free Exercise Clause, forms the constitutional right of freedom of religion. The Establishment Clause and the Free Exercise Clause together reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Okay, very, very, very important. The executive department is the department of Congress. Okay, is the legislative, executive, and judicial part itself. It's one of the branches of government. There's only three branches: the executive, legislative, and judicial. Congress is the first branch, which is the legislative branch. The executive branch is the second branch, and the judiciary is the third branch. Okay, very, very important. And Congress, not the executive, not the judiciary. And we talk about Donald Trump, who's head of the executive department. Congress stated that they should make no law, secular or religious, respecting the establishment of religion or prohibiting the free exercise thereof. So they didn't do away with religious law. They just separated by way of what we call secularism. Okay? Very important that you need to understand that term. The Establishment Clause acts as a double security, prohibiting both control of the government by religion and political control of religion by the government. Okay? So hands off. By it, the federal government of the United States, and by the later extensions, the government of all United States and United States territories, are prohibiting from establishing or sponsoring. Hear that word? Sponsoring. We know what the word sponsor means, right? And what is the title of this lecture? Trump Capacity Interest. If you're sponsoring something that you don't have an interest in because you lack the capacity, it becomes what? Ultra virus, okay? Outside of the scope of your authority. Let's get it. The clause was based on a number of precedents, meaning things that came before. This is retrospective law versus prospective law. And one of those retrospective laws was the Constitution of Clarendon, okay? This is from our ancestors, okay? The King of England, the one who passed De Notis Ultimae for children born abroad, which is mentioned in United States versus 1 Kim Ark, which we're talking about in regards to not just soil, but just sanguineous rights and inheritance to what inheritance of an estate that was left by our ancestors. Okay, very important. All right. So the clause is based on a number of precedents, including the Constitution of Clarendon. What is the Constitution of Clarendon first? You're never going to hear this on any other platform, my brothers and sisters. I'm coming to you as myself, okay? I'm not adjusting my garb because the majority of those who listen assume that I'm claiming to have the authority that they claim I don't deserve, okay? So I'm going to humble myself and come at you under the same authority as a result of the capacity and interest that I inherited, okay? Consciously. I wasn't taught this. I learned this myself. So everything I'm saying was self-taught. The Constitution of Clarendon was a set of what? Legislative procedural enactments by Henry II of England. Henry II was the son of Godfrey, the son of Fulk, the ruler of Jerusalem. This is in the 12th century. Henry II, okay, of the Angevin Plantagenet kings, okay? These were Anglo-Saxon, later to be called English people, okay? And we go back to the identity or the ethnicity or the nationality of the English people. The only way you can identify them is with the church because there was no science to prove ethnicity at that time. That didn't come until the 19th century, okay? So if you want to understand your identity as an English person, whether you're talking about just soul or just sanguineous, that belongs or can only be found in what? The church, okay? Very important. Let's look at, The Constitution of Clarendon was set up a legislative procedural enactment by King Henry II of England in 1164. The constitutions were composed of 16 articles representing an attempt to restrict ecclesiastical privileges and to curb the power of the church courts and the extent of the papal authority in England. When you're talking about papal, you're talking about the Roman Catholic Church, which is responsible for the creation of the Church of England. Not the English Church, but the Church of England, which was created as a result of the Gregorian Reformation by converting the Anglo-Saxon, i.e. English people, into Roman Catholic Christians and not the Christians that Christ created. Okay, very important. All right. So in the Antarctic parts, so in the Antarctic archaic and Nordic conditions of Henry II's predecessor, Stefan, and Stefan was related to William the Conqueror. Okay? He was the son of Henry I, the son of who? William the Conqueror, who brought influentism to the Middle Ages, and it extended all the way up into modern day with the grants given from George Carteret to John Berkeley from Charles II, which was done away with in 1795, February 18th, we'll talk about in a second. Okay, that's the Title 46 uh, revised statute in New Jersey that done away with feudalism. Okay, very important. Operative law. Okay, the Constitution was claimed to restore the law as it was observed during the reign of who? Henry I, who was the son of who? William the Conqueror. Okay, very important. All right. So the Establishment Clause was not only rooted in the Constitutional Clarendon, it was also rooted in the Bill of Rights of 1689. This when you get into what we call the monarchs of Britain or the British monarchs. Okay, very important, which didn't become unified with England until the Union of 1707. Prior to that, England controlled all this. Okay, very important in the first Constitution of Pennsylvania and New Jersey. An initial draft by John Dickinson was prepared in conjunction with the draftings of what? The Articles of Confederation. Very, very, very important. Let's move on. So, based upon this authority and their claim was done based upon a what we call a retrospective term called prescription of sovereignty. Once again, a prescription of sovereignty. Everybody write that word down. A prescription of sovereignty. Prescription in the international law is a sovereignty transfer of a territory by open encroachment by the new sovereign upon the territory for a prolonged period of time, acting as the sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easement by prescription for private real estate. Very important to understand that. Easement means a use and property that does not belong to you. What property? Real estate. What is easement? Is a non-possessory right to use or enter onto the real property of another without possessing it. Okay? Very important for you to understand that term going further on into this lesson. Okay? Because we're talking about Christ or the Antichrist, okay, having the power to restore your inheritance. I didn't say that. Donald Trump said that, and he's not even related to the church. Okay? He's not even affiliated with the church because he lacks the capacity, so therefore he lacks the interest. Okay? But yet, we walk around seeing pictures and posts of him, AI images of him acting as Jesus, or pictures next to him as Jesus. You don't believe me? Let's check it out. Okay, everybody ready, all right?
Now my eyes shall be open and my ears attent to the prayer that is made in this place.
President Trump read a passage from the Bible as part of a week of national scripture reading that comes amid some turbulence for the president and the religious community.
Then will I establish the throne of my kingdom according to as I have covenanted with David your father.
Trump has feuded with the Pope over the war in Iran and faced backlash from religious conservatives after posting an AI-generated image of himself that many likened to Jesus Christ and was criticized as. Amid that backdrop, the president turned to the Old Testament, reading a passage that talks about humility, turning away from wicked ways, and forgiveness.
If my people, which are called by my name, shall humble themselves and pray, and seek my face, and turn from their wicked ways, then will I hear from heaven, and will forgive their sin, and will heal.
Did y'all hear that? Let's just listen to that one more time.
Now my eyes shall be open, and my ears attent to the prayer that is made in this place.
President Trump read a passage from the Bible as part of a week of national scripture reading that comes amid some turbulence for the president and the religious community.
Then will I establish the throne of my kingdom according to as I have covenanted with David your father.
Trump has feuded with the Pope over the war in Iran and faced backlash from religious conservatives after posting an AI-generated image of himself that many likened to Jesus Christ and was criticized as blasphemous. Amid that backdrop, the president turned to the Old Testament, reading a passage that talks about humility, turning away from wicked ways, and forgiveness.
If my people, which are called by my name, shall humble themselves and pray, and seek my face, and turn from their wicked ways, then will I hear from heaven, and will forgive their sin, and will heal their land.
Okay. There you heard it. Now let's ask ourselves this question. We just read what secularism is, and we just read the Establishment Clause. Okay? This is what we call the separation of church and state. Okay? This is called the separation of church and state. So any person who represents the secular world cannot have the capacity or interest with the church or the church doctrine. This will be considered ultra virus based upon the Establishment Clause. Nor can any religious figure interact on a political uh, uh, framing as a result of the interest and capacity. If they are, then they are in fact violation of religious law. Okay, from a religious standpoint speaking. Okay, all right, but when we read it from or interpret it from our understanding, we understand that the law has been secularized. Religious law has been secularized. Okay, so there is an application of God's authority, i.e., capacity, in lieu of the interest of healing the land. Okay, and healing the land is returning the land back to those who it belongs to. Okay, this is the whole issue in regards to what we call the citizenship clause, okay, or who can become a citizen that before SCOTUS right now, all right? That's the very reason why this is before the court, all right? Because Trump is either what? The Antichrist or Christ. One of the two. Let's look at that for a minute. Trump is either the Antichrist or Christ, okay? Either one of the two. The only way we can know that to be true or not is to, once again, define what secularism is in regards to the Establishment Clause. Hold on for a second. All right. So if we understand what capacity and interest means when you're dealing with a separation of church and state, we understand that the capacity and interest of an entity cannot be that of an entity that's affiliated with the church because there's a separation of church and state. Okay, so when we look at the capacity of Trump, okay, based upon his interest he have in regards to the language he's using, all right, we understand that this is in fact an ultra virus issue. What does ultra virus mean? Let's look at that word. Ultra virus is a Latin phrase used in law to describe an act that requires legal authority but is done without it. It is its opposite. An act done under proper authority is intravirus. Acts like acts that are intravirus may equivalent to be termed valid, and those that are ultravirus are termed invalid. Okay, so if you don't have the capacity in lieu of whatever interest you claim to have, especially in regards to land, okay, then it's ultravirus because you're outside of the scope of your authority. Okay, very important we understand that. And we understand through the Establishment Clause and through secularism, there's so much that you can do as a secular entity, and there's only so much you can do as a religious entity as a result of the Establishment Clause and secularism. Very important that you make the distinction. Okay? So now we're talking about the capacity and interest of the church. Okay, because Donald Trump is making reference to the church, he's making reference to Christ, and he's making reference to uh, two distinct churches, the English church and the Roman Catholic church, because Jesus is not a part of the English church. That term or that concept came with the Roman Catholic Church, who had all the Anglo-Saxons, the true Christians, converted to that Roman Catholic Christianity by way of the Gregorian mission in the 6th century by Pope Gregory and what's his name? Pope Gregory and Alexander the Great. Not no, pardon yourself. Pope Gregory and Augustine. What's it? Pope Gregory the first and Augustine of Canterbury. I got. Let me just look it up. Gregorian mission. My job here is to teach. Gregorian mission. Augustinian mission was a Christian mission sent by Pope Gregory the Great to England in 596 to convert the Anglo-Saxons. The mission headed by Augustine of Canterbury. By the time of the death of the last missionary in 653, the mission had established Christianity among the southern Anglo-Saxons, which is a term. It's not the identity of the English people. It's just a term that was created by those who are trying to identify with the people who were not called Anglo-Saxons. Okay, these were in fact Berbers. Okay, dark-skinned Berbers. Okay, under a loose term that was loosely fitted to people who didn't deserve that term as a result of the new classification of those that ethnicity as English people, now known as white people, okay, or free white persons, okay, through the Naturalization Act of 1790. Very, very, very important. This is before the Supreme Court. So it says, by the time of the death of the last missionary in 653, the mission had established Christianity among the southern Anglo-Saxons, along with the Irish and the Frankish mission. It converted Anglo-Saxons to other parts of Britain, as well as influenced the Hiberno-Scottish mission to continental Europe. Very, very, very important. So this is why you must understand what? Anglo-Saxon law. So let's do that. Let's understand Anglo-Saxon law. What is Anglo-Saxon law? Anglo-Saxon law, later called a lagu, law and doom decree or judgment, was a legal system. Okay, we talk about a legal system of Anglo-Saxon England going all the way back to the 6th century before the Norman conquest of William the Conqueror and his son Henry the First. Okay, and his son Stefan. Okay, it was a form of Germanic law. This is why he's saying Anglo-Saxon, because the Anglo-Saxons were Germanic tribes who migrated across to what they call what was it called? I talked about this lesson a while ago. What was called it was called the Great Migration. Okay, I'm not going to get into that because for the sake of today's lesson, but it was called the Great Migration when the Germanic tribes migrated and emigrated to England and then identified themselves as the Anglos and the Saxons. Okay, the original people of that landmass were actually the ancient Celtics or the ancient Britons, which were still in fact us. Okay, it was a form of Germanic law based on unwritten custom known as folk right. Key word, folk right, and on written laws enacted by kings at the advice of their witten or council. By the later Anglo-Saxon period, a system of courts had developed to administrate the law, while enforcement was the responsibility of the eldermen, the royal officials such as sheriffs, in addition to self-policing by local communities. Okay, very, very, very important. And this is the reason why I need to go to the 1911 Encyclopedia Britannica. So let's go there. Because I said we were Berbers. Now, this encyclopedia came out of Edinburgh, Scotland. Okay, Scotland. And they're associating the customs of the Berbers with the customs of the Anglo-Saxons. Okay? They're associating the customs of the Berbers with the customs of the Anglo-Saxons because they were both agricultural groups of ethnicities that main purpose was maintaining the continuity of land possession. Okay? Very, very important. Let's find that. Because we're talking about Anglo-Saxon law, which they call folk right. Okay? You heard the term kinfolks. All right? That's where the term comes from. Right here. Berbers. All right? Ethnology. Now, we know we didn't have the study of ethnology to the 19th century. Okay? But these Berbers goes back to the Stone Age. Okay? Very, very important. They go back to the Stone Age. Well before the so-called people identify as Egyptians. I didn't say this. This is what the Encyclopedia Britannica said. All right, let's see. It said, in regards to the ethnic relations of the Berbers, there has been much dispute. The antiquity of their type is evidenced by monuments of Egypt, where their ancestors are pictured with the same comparatively assumed to be blonde features, which many of them still display. The Aborigines of the Canary Islands and Guanches, we know Guanches is a part of what we call the Canary Islands, and we know they were in fact go by what we call the Berber calendar, okay? But they are affiliated with the Spaniards or Spain. It goes on to say that would seem almost certainly from the remains of their language to have been Berbers. But the problem on the actual origin of the Berber race has not yet been solved. Let's see why. Perhaps the most satisfactory theory is that of Sergi, who concludes that Berbers is in the Mediterranean race. General LLC for Herbie, if I'm pronouncing that right, regards them as indigenous Libyans mingle with fair-skinned people. You hear that? Mingle with fair-skinned people. Let's go down a little further. The Where is that? The megalithic monuments of Iberia and Celtic Europe have their counterparts in Northern Africa. It is suggested that these were all erected by the same race, by whatever name they be known. Berbers and Libyan in Africa, Iberians in Spain, Celts and Gauls and Picts in France and Britain. Did you hear that? These were in fact Berbers. How do we know that? It said, in spite of the history of the foreign conquest, when we say foreign conquest, we're talking about prescription of sovereignty. We just defined that word. Somebody claimed to be the sovereign. It says here, in spite of the history of the foreign conquest, Phoenician, Greek, Romans, Vandals, Arabs, and French. These are the foreigners and the conquestors. The Berber physical type and the Berber's temperament and nationality have persisted since what? The Stone Age. Okay? It said the Stone Age. I didn't say that. The people who wrote this encyclopedia says that. Though considerable individual differences of type may be found in every village, the Berbers are distinctly a white race. This is why you have the Naturalization Act of 1970. I'm part of 1790. Okay, this is why when the founding fathers classify themselves, they classify themselves as white race. Okay, not because of their ethnicity, but because of their complexion. Okay, very, 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 very important to understand that, and I'm gonna prove it by case law in a second. So, though considerable individual differences of types may be found in every village, the Berbers are distinctly a white race, and the majority would, if classed with European costumes, pass unchallenged as Europeans. Did you hear that? Did you hear that? So you must challenge people trying to identify themselves as either white people or Anglo-Saxons, because 9 times out of 10 they're not. Why? Because I'm about to go here. This fact has been emphasized by Dr. R.G. Latham, who writes, all that is not Arabic in the Kingdom of Morocco, all that is not Arabic in the French province of Algeria, and all that is not Arabic in Tunis, Tripoli, or Fez is what? Berbers. Okay? This explanation lies in a profound distinction of character. The Arab is a herdsman and where am I? And a nomad. The Berber is a agriculturist and a townsman. You hear that? That's one thing they had in common, that they were agriculturists. Their job was their customs and traditions that were based upon the common law was based upon a assembly of was a custom of assemblymen, okay? Not religion, but assemblymen, okay? Based upon laws. It says the Arab had built his social structure on the Quran. That's religious, which inculcates atletism, aristocracy, and theocracy. The Berbers, despite his nominal Mohammedanism, and this is by conquest, enslavement, etc., is a democrat with his Jimna called written Ma and his Kanun or unwritten code called the what? The Magna Carta of the individual liberties as opposed to the community's good. So the one thing that the Anglo-Saxons had in common was not just agriculture, but their assemblymen made up of their government, which at that time called written mind and the Magna Carta. So let's go back to Anglo-Saxon law and sum it up. So we're either called white people or Anglo-Saxon. Okay, very, very, very important. All right, let's discuss this right now. Case law, Enway Hassan. Okay, case law, district court case. Enway Hassan, 48F, supplement 843, East District of Michigan, 1942 case. It says to summarize the approach which must be followed in deciding whether a particular person is applying for citizenship is a white person. There go that word again, white person. And we know that scientific knowledge of ethnicity didn't come out to the 19th century, okay? But the court is trying to distinguish who will be classified as a white person based upon 2 tests. One test is the meaning of the Naturalization Act of 1790, and the other test based upon ethnicity or genealogy. Okay, a person or individual classifying himself as part of the original group of people that he claimed to belong to. All right, and that's not just based upon the color of a person's skin. All right, that would be by way of what we call apparition. All right, so it says to summarize the approach which we must follow in deciding whether we as particular persons, especially applying for citizenship here in North America, is either a white person within the meaning of the statute. And what statute is that? The Naturalization Act of 1790, which deals with the aberration of the skin and not one's genealogy or ethnicity, whether the proved ethnicity or nationality was invented, whether it was invented yet. The fact still remains that when the court is deciding this case, the two-prong test is nationality based upon genealogy and nationality based upon the color of a skin. So it says Supreme Court, it is necessary to determine first the particular group or racial subdivision to which the individual belongs. And practical effects, listen y'all, proof of this fact is a matter of what? Genealogy. Okay? Right there. This case is in the 20th century, 1942. All right? The 19th century preceded it. And if science proving one's genealogy or ethnicity didn't come out, then what type of genealogy were they in fact talking about? Because there was no test to prove it. Okay? They didn't have Ancestry.com and all the other ways to prove your ethnicity or what group you come from or your nationality. Okay, they didn't have that. That science was not invented yet. Okay, but yet they're talking in the 19th century and later 20th century about the ethnicity or genealogy of not just a person with whether he had light skin or dark skin, but if he in fact did qualify as members of the whole group, okay, which are not seen as unincorporated associations, but are incorporated within the association of that group of people. Very important, unincorporated association versus incorporated association, because the majority of you are, especially if your natural people, are not incorporated. Okay? You're nobodies. Let's prove it. An individual who presents an aberration from the color of skin of a group of which he is a member, such as a light-skinned Chinese or Japanese or white person, as in the Naturalization Act, or a dark-skinned Anglo-Saxon, does not thereby acquire a different status under the Act from other members of its group. So they not only identify the ethnicity of the Anglo-Saxon people as dark-skinned based upon the aberration of the skin, they also associated the dark-skinned people with the genealogy of the whole group of people, which apparently must have had what? Dark skin. Okay? Very important. Of course, when an individual applying for citizenship has a skin of a different color, then it's usual for the members of the group from which he claims to come a strong burden of proof then rests upon to show by the usual methods of proving genealogy that he is in fact a member of that group. So what is the ethnicity of the English people? Prior to that, were called Anglo-Saxon. What is their nationality? What is their race? What is their ethnicity outside of the fact that they're being classified as dark-skinned and not white-skinned, because it said that they were dark-skinned here. Right there. That's case law. So we got an advantage right there about those who claim to be Anglo-Saxon who got white skin, because they have now proved that because of that white skin, you are still members of the group who are having nationality even though they got white skin. You haven't satisfied the nationality ethnicity criteria. All right. Very, 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 very important to understand that. Let's continue. Of course, when an individual applying for citizenship has a skin of a different color than the usual of that member of that group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of proving genealogy that he is in fact a member of that group. So let's prove our genealogy without the aid of science. Okay? Let's prove the ethnicity or genealogy of the English people, i.e. Anglo-Saxon, i.e. Berbers, without the proof of science. Let's look at it. English national identity. This is a historical outlook of the identity. English national identity before the age of science. Okay? And we just read The 1911 Encyclopedia Britannica was the 1911 Encyclopedia. Okay, and they said the Anglo-Saxons had more in common with the Berbers than they did with Chinese, Japanese, or even white people for that matter. If you're dealing with from a genealogy, okay, very important. All right, it just said in Ibrahim Hassan that you must satisfy two criteria: the aberration test and the genealogy test. Okay, so we already proved the aberration test because in the case it said they were dark-skinned Anglo-Saxons. Okay, that part is met. What about the genealogy test? Let's look at the identity of the Anglo-Saxons, i.e., the English people, because we all speak English, don't we? Even white people speak English, but do they claim to be the English based upon the nationality test? No, because if they would have, they would not have been using the Naturalization Act of 1790, because that only deal with what? A color or aberration of a skin. So it says, according to some scholars, a national identity of the English as the people or ethnic group dominant in England can be traced to the Anglo what? Saxon period. So that means that according to that case law, the Anglo-Saxons were in fact dark-skinned. Okay? Dark-skinned, okay? And if they were dark-skinned then they were also classified as free white persons under the Naturalization Act of 1790. We got case laws to back that up, okay? So to find out the ethnicity, genealogy, or nationality of the English people, you cannot go to science. You have to go to what B said the origin of the English people is. Let's look at it. The ecclesiastical history of the English people. All right? Because apparently Trump and his capacity and interest, all right, whether he's the Antichrist or Christ, just said about restoring the land. Didn't he say that? If my people will hear my voice or hear my call, whatever words he said, he will heal the land. Okay? The ecclesiastical history of the English people, written by Bede in 731 AD, Annus Dominius, which means the Lord was there at that particular time, is the history of the Christian churches in England. You hear that? And of England generally. Its main focus is on the growth of Christianity. So, in fact, the Anglo-Saxons will be, in fact, the true Christians. Okay? Way before the Gregorian mission when we were converted to the Roman Catholic Christians, because the ethnicity of our identity is rooted in what B said, the church, okay, without the aid of science. It was composed in Latin and believed to have been completed in 731 when B was approximately 59 years old. It's considered one of the most important original references on Anglo-Saxon history, and according to some scholars, has played a what? Key role in the development of the English national identity. Did you hear that? English national identity. And it's related to the church. Not some family record filed at the county recorder's office, not in the hospital, but it's affiliated with God's church. Very important that you understand that, because that's where the true Christians are. Let's continue on with this marvelous lesson. Let's read a little bit more of this Anglo-Saxon law. Development. I'm going to show you how they stole it. The founding fathers stole it. Okay? Before Christianization. The native inhabitants of England were the ancient Celtic Britons, as they stated in the 1911 Encyclopedia Britannica. The unwritten Celtic law was learned and preserved by the Druids, who in addition to their religious role also acted as judges. After the Roman conquest of Britain and the 1st century, Roman law was operative, at least concerning Roman citizens, but the Roman legal system disappeared after the Romans left the island, and the 5th century, this is when the Anglo-Saxon or the Germans immigrated to England after Rome left. Okay? You must know your historical insight. In the 5th, 6th century, the Anglo-Saxon migration from the continent of Europe and established several Anglo-Saxon kingdoms. These had their own legal traditions based on Germanic law and owed little of anything to Celtic or Roman influences. Anglo-Saxon law largely derived from unwritten customs termed folk right, the rights of justice of the people. Once again, folk right. Did you hear that? Folk right. So the ancient law before feudalism came in was called the folk right. Okay? Folk right was the ancient laws of the Anglo-Saxons, and the Anglo-Saxons' identity is related to the church. And we know there's a separation of church and state in modern day, so none of the people who are dealing with secularism can be God's people. Okay, you have to be affiliated with the church, historically sound, and the history related to the English church, going all the way back uh, 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 before the Christianization and after the Christianization of us by way of the Gregorian mission and what we call the English Reformation that was done by who? Alfred the Great and his successors. How we know it? Just look at it. It's right here. Right here. After the Christianization of the Anglo-Saxons, written law codes or dooms, this is called folk right, were produced. The Christian clergy brought with them the art of letters, writing, and literacy. All right? Of course, the white people were illiterate because they didn't have science. They didn't know anything, but yet, before the invention of science, our ancestors were literate and they had writing forms, they had letters, they had arts, etc. They created illuminated manuscripts to document our story. The oldest Anglo-Saxon law codes, especially those from Kent and Wessex, reveal a close infinity to the Germanic law. Why? Because the Germanic people preserved it. The first written Anglo-Saxon laws were issued around 600 by Ethelbert of Kent. This is when they were called separate kingdoms, okay, until they were united to what we call the Kingdom of Wessex by Alfred the Great. Writings in the 8th century by who? Venerable Bede, the same one who created the English identity and said it was only identified with the church. Okay? Venerable Bede commented that Ethelbert created his law codes after the example of the Romans. This likely refers to the Romanized people such as Franks, whose Celtic laws were codified under Clovis I of the Merovingian dynasty, or what we call the Claringian dynasty, who were Frankish Nordic Vikings. Okay? Very important to understand your history. The actual key part right here. The actual legislation, however, was not influenced by Roman law. Rather, it converted older customs into written legislation and reflected the role of bishops in drafting it, protecting what? The English church. The first seven clauses dealt solely with the compensation for what? The English church. You better understand what I'm saying to y'all. Let's continue. Folk right could be broken or modified by special law or special grant, and the fountain of such privileges was the royal power. Alterations and exceptions were, as a matter of fact, suggested by interest parties themselves and chiefly by what? The church. Thus, a privileged land tenure was created called what? Bookland. This is where your county recorder office come from. You hear me? Your county recorder office was created by way of bookland when deeds became recorded through what we call the practice of library and season. Okay? The rules as to the succession of kinfolks were set at naught by concession of testimony power and confirmation of grants and wills. Special exemptions from the jurisdiction of the hundreds, I now called counties, and special privileges as to the levy and fine, called soccage, were conferred. In process of time, the rights originating in royal grants or privileges overbalanced, as it were, folk right in many respects, and became themselves the starting point of a new legal system, the feudal one under who? William the Conqueror. Now watch what it says. In the 9th century, the Dane laws were conquered by Danes and governed under Scandinavian law. These were also the Germanic tribes who migrated to England. Okay, the word law itself derived from the Old English Norse word laga, starting with Alfred the Great. The kings of Wessex united the other Anglo-Saxon people against their common Danish enemy. In the process, they created a single kingdom of England under the kingdom of Wessex. The unification process was completed under Ascerton, which means noble stone. There is a good deal of resemblance between the capitularies legislation of Charlemagne and his successor, Frankish king. One, and on the other hand, the acts of Alfred, Edward the Elder, Ascerton, and Edgar, our Christ, our Jesus Christ, the one right here. All right. On the other, a resemblance called forth less by direct borrowing of Frankish institutions than by a similarity of political problems and conditions. Did you hear that? The Norman conquest of 1066 ended the Anglo-Saxon monarchy, but Anglo-Saxon law and institutions survived and formed the foundation for what we now call today the common law. You hear that? The common law. So now let's go to Juan Kimmel Art. Let's go to Juan Kimmel Art. Where is it at? Right here. This is United States versus Juan Kimmel Art. Okay? 169 U.S.649 1898. At 1898 case. This is the case in deciding citizenship that's before the Supreme Court right now, only based upon just soil. All right, they ain't touch on just saying greenness. As a result, they have nothing to do with their notice ultima children born abroad who are able to inherit the inheritance left from these kings who put these laws in place in regards to our lost estate, which Donald Trump is talking about restoring. So once again, is he the Antichrist or Christ? That's left for you to decide. Okay? It says right here. This is Juan Kimmel Art. Everybody get that case. Go to page book and page. Where is it at? Page 169 U.S. 655. We're going to page 169 U.S. 655. Let's find that. All right, here we go. This is Juan Kimmel Art. All right, everybody get this case. The Constitution nowhere defines the meaning of these words. Oh, let's go back up some. The 15th Article Amendment declares that the right of citizens of the United States to vote should not be denied or abridged by the United States or by any state on account of race, color, previous conditions of servitude. The Constitution nowhere defines the meaning of these words, either by way of inclusion or exclusion, except insofar as this is done by the affirmative declaration that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, and this is in other respects, it must be interpreted in light of what? The common law, the principles and histories of which were familiarly known to the framers of the Constitution. Okay? Now we know the framers' Constitution citizenship clause is based upon the Naturalization Act of 1790, which only has to do with the aberration of the color of skin. That's the first test. The second test, are you a member of that group where you descend down from based upon a genealogy test? And we know when we talk about genealogy tests, we have to go back into uh, way before the 19th century when those forms were created to actually prove genealogy or ethnicity. And we know that B said the genealogy or ethnicity of the English people goes back to the church. That's why when children were born, they were registered with the church and not in the hospital. Okay? So we understand that the Constitution only assumes that a person naturalized or born is subject to the jurisdiction of the United States or the states in which they reside. Okay? And that must be looked at in light of the common law that was familiar to those framers of the Constitution. Okay? So the common law that was familiar to those framers who formed that Constitution was now based upon genealogy or ethnicity. It was based upon the aberration of color skin because it was based upon the Naturalization Act of 1790. Okay? Very important. Let's continue. The language of the Constitution, as has been well said, cannot be understood without reference to what? The common law. Okay? The common law. Before you had the common law, you had the folk right. And the folk right was the right of allodial possession of land. That's what folk right means, or where it comes from. The allodial possession is now called free and common soakage. Chief Justice Watie, when construing in behalf of the court, the very provision of the 14th Amendment now in question said that, let's read it, the Constitution does not in any word say who should be a natural born citizen. Resort must be had elsewhere to ascertain that. And he proceeded to resort to the common law as an aid in the construction of this provision. Let's continue. In Smith versus Alabama, Mr. Justice Matthews delivered the judgment of the court. And this is what he said. There is no common law of the United States in the sense of a national customary law. Okay? The national customary law of the church will be that of the church, but they separated it through what we call secularism through the Establishment Clause with the separation of church and state, as we see in Everson versus Board of Education. Okay? Very important. And that's in New Jersey's case. There is no common law of the United States in the sense of a national customary law distinct from the common law of England as adopted by the several states, each for itself, apply as its local law and subject to such alteration as may be provided by its own statutes. Okay? There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law in order to be read in light of its history. So how much of you know about the history of the English people, being that you speak the English language? How many of you know it? None of you do, because none of you know what I'm telling you. All right? This is all brand new to you. Okay? The fundamental principles of the common law with regard to English nationality, listen, y'all, was birthed with the allegiance, also called legality, obedience, faith, or power of what? The king. The principles embrace all persons born within the king's allegiance and subject to his what? Protection. Children born in England of such aliens were therefore natural born subjects, but the children born within the rim of foreign ambassadors or the children of alien enemies born during or within their hostile occupation, prescription of sovereignty, a part of the king's dominion, were not natural born subjects because not born within the allegiance and the obedience or the power, authority, capacity, or as who would be said at that day within the jurisdiction of the king. You hear that? This fundamental principle with these qualifications or explanations of it was clearly thought quantity stated in the leading case known as Calvin's case or the case of Post-9 decided in 1608. Okay, which we'll touch on in a second. Okay, don't forget that Calvin's case. Let's go down a little bit further. Let's go to 709. No, let's start right here. The law of England and almost all civilized countries ascribe to each individual at his birth two distinct legal states or conditions, one by virtue of which he becomes the subject of some particular country, binding him by the tie of natural allegiance, and which may be called his political status. You were born with the capacity because of your political status as a result of your allegiance to the king. Okay, this is a contract. The king was the overseer of this church before the church became secularized through secularism, through what we call the Establishment Clause. Okay, which separated church and state. That's when the church law became secularized. It never went anywhere. Okay, why you think Donald Trump talking like he talking? Okay, why you think he talking like he talking? Let's continue. It goes on to say that another by virtue of which, let me backtrack. The law of England and almost all civilized countries ascribe to each individual at his birth two distinct legal states or conditions by virtue of which he becomes the subject of some particular country, binding him by that tie of that natural allegiance in which he may be called his political status. Then there's another by virtue of which he has ascribed to him by the character of a citizen of some particular country, and as such it is possessed of certain municipal rights and subject to certain obligations, which the latter character is a civil status or condition of the individual and may be quite different from what? Your political status. This is what you fail to understand. Your political status is your capacity and your interest to tie to the natural leases to the king and the king's land. Okay? You must understand that. Okay? So you got two status, civil status and political status. How do we know that? The founding fathers knew that. Let's look at it. It's right here. I'm not making this up. So it says we must look at the common law in light of the history of the common law as the framers understood it. Okay? As the framers of the Constitution understood it. Let's look at how they understood it in the same case, which nobody talked about Solicitor General or the opposing counsel or the Supreme Court justices. None of them talked about what I'm about to show you right now. All the answers are here, brothers and sisters. We just fail to pay attention. Okay, here we go. Okay, here's the proof. If we have to look at the common law in light of the history of the common law as the founders understood it, let's look and see how the founders understood the common law in regards to birthright citizenship. Because our ancestors understood birthright citizenship, they preserved it. Just so and just sanguineous. It's right here. In the same case. I'm almost here. Right here. Page 25. Now, this is the case. This is the act, that we all should be familiar with in regards to understanding what's going on in the present day or modern day. This act right here is going to cause a big problem. The Notice Ultimae, also known as the Statutes of Children Born Abroad Act of 1350, was an English statute during the reign of Edward III. It regulated the rights of those born overseas and was the early precursor of British nationality law. So the Notice Ultimae was passed by the Plantagenet king, who was the great-great-grandson of Henry II, son of Godfrey V, Count of Anjou, son of Folk, ruler of Jerusalem. Okay? It was an English statute, so this is law, y'all. It regulated those born overseas and was an early precursor of British nationality law and others, dating from the 1351 during the early part of the Hundred-Year War, and addressed the issues of inheritance by foreign-born children of topical problem. Okay? Foreign-born children. Yeah, we're foreign to the United States, but we're still on our homeland because prior to the United States being here, this was under the jurisdiction of what we call the English Crown. Okay? Very important. The status of Edward III was invoked over 200 years later in two matters. The first one involved what? Calvin's case. And the other one involved the union of the crown because they were trying to inherit the foreign-born estate that was preserved by this legislative act. They were trying to take over the land which was preserved by King Edward III. Okay? How I know it? Let's go back to 1 Kim Ark. All right? 1 Kim Ark. This same king is right here. What is he doing there? What is that king doing there? Everybody needs to ask themselves, what is he doing there? And why aren't anybody talking about the king? All right? And we ain't talking about the personal or the person Edward III, but we're talking about his capacity. All right? His capacity, his authority, that's what we're talking about. That's in question. Was it ultravirus or intravirus? Okay? Both in England and the United States, indeed, laws has been passed. If you don't follow the law, it's intravirus. It's ultravirus. Outside of the scope of your authority, outside of the bounds of exceeding your bounds, okay, or what we call overreach, all right, versus intravirus, which means within the scope of your authority, within the bounds of your capacity, okay. So we see here the laws of England and the laws of the United States, according to the statute, are what? One and the damn same. All right? Both in England and the United States, indeed, statutes have been passed at various times enacted that children issues born abroad of English subjects or of American citizens. Did you hear that? England subjects are now or American citizens, meaning that they were English subjects at one time. Now they're identified as American citizens. Okay? And when you say English subjects, you're talking about Anglo-Saxon subjects, now called American citizens. How I know it? It says it right here. United States versus Sing Tuck or Do. 194 U.S. 161, 1904 case. Okay? Right here. Must an American citizen seeking to return to this his native land, remember we're talking about de notis ultima re, the law governing children born abroad in lieu of their inheritance from their predecessors, i.e. your parent. Just sanguineous, not just soil. That don't matter. Just sanguineous. And this de notis ultima re case 1350 by Edward III was not a part of the common law. It was a legal fix. Okay? It was an artificial statute created to protect our inheritance from our parent, which was not our mother and the father. It was the church, because the genealogy or ethnicity of the English people or Anglo-Saxons, which were in fact Berbers, goes back to the church. And when the church is responsible for ecclesiastical or public land, the preservation of ecclesiastical property or public property, okay, through the continuity of what? Office. We must understand that. So must an American seeking to return to his native land be compelled to bring with him two witnesses to prove the place of his birth, or else be denied his right to return and all opportunities of establishing his citizenship in the courts of his country? Question. No such rule is enforced against an American citizen of Anglo-Saxon descent. So that meant that you are of Anglo-Saxon descent, and if you're dark-skinned, that's because of the genealogy test, okay, and not because of the aberration of a color of skin. Because Anglo-Saxon is not a color of skin, all right, as the founding fathers would want you to believe in one Kimmel art, because they took the folk right of the Anglo-Saxon, who, based upon the aberration of color of skin, were in fact dark skinned, now classified as white, because white, based upon the Naturalization Act, had to deal with the ancestry of those who descended from the European continent. And who were those people? The Anglo-Saxons, i.e. Berbers, okay? Very important. So it says, no such rule is enforced against an American citizen of Anglo-Saxon descent if this be as claimed a government of laws and not of men. I do not think it should be enforced against American citizens of Chinese descent as well. So here we're showing that American citizens are in fact Anglo-Saxon or English subjects of the king, which has a natural allegiance because your political ties not based upon your civil ties. Okay? Does that make sense to y'all? I hope so. Let's continue. Back to United States versus one Kimar. Both in England and the United States, indeed, statutes have been passed at various times enacting that certain issues are born abroad of English subjects or American citizens, respectively, should inherit to some extent at least the rights of their parents. This is just saying Greenius, okay? For that to apply, if you're Anglo-Saxon, you need that 1350 Act by Edward III, and it's right here. Okay? It's right here. All right? Both those statutes apply only to cases coming within their purport. So if you don't bring it, it won't be argued. Remember, the courts have jurisdiction over subject matter if they got jurisdiction over persons. Okay? And for that, you must fall within the jurisdiction of the court. Okay? Who put those courts there? Our ancestors did. Okay? The earliest statutes that was passed in America and England, as we read, was that of Edward III and arose a parliament of Edward III, okay, in 1343. It stated that before these times, there had been great doubt of difficulty among the lords of this realm and the commons, as well men of the law as others, whether children who are born in parts beyond the seas, this is called overseas territories, ought to bear the inheritance, this is a birthright, after the death of their ancestors in England, because no certain laws had been thereon ordained. We're not talking about mother and father, because we understand what B said, the ethnicity of the English people is with the church. You hear that? It's with the church, okay? Edward was overseer of what? The English church. We must understand that, brothers and sisters. Yes, you must understand that. Let's continue. And the kings and lords of common, it was unanimously agreed that there was no manner of doubt that the children of our Lord the King, whether they were born on this side of the sea or beyond the sea, should bear the inheritance of their ancestors. And in regards to other children, it was agreed in this parliament that they also should inherit whatever they might be born in the service of the king. Okay, this is why it said that the Notice Ultima case by Edward III, which we're reading right now, was used for over 200 years to justify and to clarify who owned what and who it belonged to. Okay, very, very, very important. But because the parliament was about to depart and that the business demanded great advisement and good deliberation how it should be best and most surely done, the making of the statute was put off until the what? The next parliament. By reason apparently of the prevalence of the Black Plague in England. Okay, or the Black Plague in England. We don't understand that there was a synonymous plague that was happening here in North America. All right, that we can reference, but I'm not going to do that in this present time. Okay, that'll be done in a later lesson. But it goes on to say, by reason apparently of the prevalence of the plague in England, no act upon the subject was passed until Edward III in 1350, when Parliament passed an act entitled "A Statute for those who are born in parts of the sea and parts beyond the sea," by which, after reciting that some people be in doubt of if the children born in parts beyond the sea out of the legions of England should be able to demand inheritance within the same legions or not, whereof a petition was put into Parliament of Edward III, and has not at the same time wholly assented, then it was agreed and affirmed that the law of the Crown of England is and always has been such that children of the King of England in whatever parts they be born in England or elsewhere, be able and ought to bear the inheritance after the death of who? Their ancestors. It didn't say mother, father. Okay, it said your ancestors. Two, also agreed that certain persons named which were born beyond the sea out of the legions of the King of England should be from henceforth able to have and enjoy their inheritance after the death of their ancestors in all parts within the legions of England, as well as those that should be born within the same legions. And further agreed that, sorry, and it was further agreed that all children inheritors, which from henceforth should be born without the legions of the king, whose fathers and mothers at that time of their birth be and should be at the face of the legions of the King of England, shall have and enjoy the same benefit and advantages to have and to bear the inheritance within the same legions as the other inheritors aforesaid, in times to come, so always that the mothers of such children do pass to sea by the license and wills of their husbands. Let's continue. It has sometimes been suggested that this general provision of the statute of Edward III was declaratory of the common law. When we say declaratory, we're talking about declaratory and injunctive relief. Okay, that's equity. You can only find that in what? A court of chancery, my brothers and sisters. So the Notice Ultima, which is the law passed by Edward III in 1350, allow us to inherit the estates that were preserved by the legislative act by Edward III. Okay, very important for us to understand that because they control the overseas territories. Everybody know? Anybody know what that means? Let's look at that up. Let's look that up. Overseas territories. English possessions. Let's look at it. Excuse me. The English overseas possessions, sometimes referred to as the English Empire. You hear that? The English Empire comprised a variety of overseas territories and colonies that were conquered or otherwise acquired by the Kingdom of England before 1707. You hear that? Look at the map. English overseas possessions in 1707. So before 1707, North America was a part of England already. And we're only talking about the eastern seaboard, okay? All right? For us to understand the western part of North America, which is on the western seaboard of North America, you got to go back to the history of Spain and France, okay? And England was still controlling that because the Angevin crown was French kings. Edward III was the English and French king. Come on, you got to know your history, brothers and sisters, in order for you to claim this inheritance. All right? So it says, these overseas possessions were controlled before 1707, and in 1707, this is when the Act of Union was created, then created what we call the Kingdom of Great Britain, or Great Britain, or whatever the hell you want to call it. Okay? Well, let's check out the origin, though. The origin. The origin goes back to who? Ashleton. Okay? Right there. All right? The Kingdom of England is generally dated from the rule of Ashleton from 927 to the rule of the House of Niglinga, if I'm pronouncing it right. From 1013 to 1014 to 1016 to 1042, England was part of a personal union that included dominions of Scandinavia. That's when you get into the Dutch, King Canute the Great, Harold Bluetooth, etc. Then in 1066, William the Conqueror, Duke of Normandy, conquered England, making it the Duchess of Crownland of the English throne. That's a very important word or term, Crownland of the English throne. Okay, we're going to define that before I close this out. Through the remainder of the Middle Ages, the kings in England held extensive territories now in France, based on the history of this duchy. Under the Angevin Empire, England formed part of a collection of lands in the British Isles, and France held by who? The Plantagenet dynasty is right there. Who was a part of the Plantagenet? Henry II, John, Richard I, which was called Richard Lionheart, where you get the term time immemorial. Okay? They represented what? Crown land. What is crown land? Let's look at it. Look at it. Come on. Where was I at? Okay, Crown Land. Crown Land, also known as royal domain, is a territory area belonging to who? The monarch, who personifies the crown. Okay, you know what the word personify means? Incarnate, incorporate. Okay, that's what it means. Personify. Capacity, y'all. That's what it's talking about. Having the same capacity. Like the president. The president has the same capacity as the previous president. When the next president comes in, they will have the same capacity in lieu of the interest based upon the office that he holds. It's a office-based system, y'all. It says Crown Land, also known as royal domain, is a territory area belonging to the monarch who personifies the crown. It is the equivalent of a entailed estate and passes with the monarchy, being inseparable from it. Today it's called the Commonwealth. Crown land is considered public land, is not part of the monarch's private estate. So it's based upon the continuity of possession of what? Crown land, brothers and sisters. Crown land, which is called the English overseas possessions, going all the way back to the English kings ruling under the French monarchs under the Plantagenet king, namely Edward III. Okay, Very, very important. All right, let's continue on. Let's go back to 1 Kim Art. Let's go back here. Now let's prove how the founding fathers stole it, since the case says that we must look at the common law, and a lot of the history as the framers understood it, and we understand that the common law was a replacement of the folk right, which was called Anglo-Saxon law, which was synonymous, as the 1911 Encyclopedia Britannica puts it, in line with the Berbers. Why? Because they were agriculturists. Their job was the continuity of possession of the land. Okay, going all the way back to the Stone Age. All right, let's get it. It's about to get gooder. It's about to get better, brothers and sisters. Did I pass it? Hold on. Nope, not yet. We're still in the same case. 1 Kim Art. This represents Pandora's box. $709. This case talk about everything, boy. Come on. Okay, let me see. Right here. Right here. Let's get it. Okay. The true bond which connects the child with the body of politic is not the matter of an inanimate piece of land, but the moral relations of its parentage. The place of birth produces no change in the rules that the children follow the conditions of their fathers, or it is not naturally the place of birth that gives right, but extraction. And to the same effect are the modern writers, as for instance, Barr, who says, to what nation a person belongs is by the law of all nations closely dependent upon what? Descent. It is almost an universal rule that citizenship of the parents determines it. that of the father where children are lawful, and where they are bastards, that of the mother, without regard to the place of their birth. And that must necessarily be recognized as the correct canon, since nationality is in essence dependent upon what? Descent. The same shit they said in Imre Mahasad. This same case. Right there. Right here. In this same case. An individual who presents an aberration for the color of skin of the group which he is a member, such as the light-skinned Chinese or Japanese or dark-skinned Anglo-Saxon, does not thereby acquire a different status under the Act from other members of his group. Of course, when an individual applying for citizenship has a skin color of different color than the usual for his member of the group from which he claims to come from, a strong burden of proof then rests upon him to show that by the usual methods of proving genealogy that he is in fact a member of that group. Genealogy, brothers and sisters. Genealogy. Okay? To what nation a person belongs to is by the law of the nation closely depends upon what? Descent, genealogy, ethnicity. When we go back to B's, since genealogy tests were not invented in the 19th century, it has to be relationship to the church. Okay? What church? The Church of England or the English Church? Two separate churches, two different body polities, two different capacities. Okay? In regards to their interests, to the continuity of the land. Okay? The lost estate. To a nation a person belongs to is by the law of all nations closely dependent upon descent. It is almost an universal rule that a citizenship of parents determines it. That of the father, where the children are lawful, and where the parents of that of the mother, the children are bastards, without regard to the place of birth, and they must necessarily be recognized as the correct canon. It didn't say secular law; it said canon. Okay, church law are canon laws. Oh, what we have here. The framers of the Constitution were familiar with the distinction between Roman law and feudal law. So we're talking about Roman law deals with church law, and feudal law deals with land. Okay? Land. Okay? They were familiar with religious law and dealing with land. Okay? And feudal law came in with William the Conqueror. They were, and as well as between obligation based on territoriality and those based upon personal and indivisible character, personal and indivisible character of origin. And there is nothing to show that in the matter of nationality that they intended to inherit to the principles derived from the regal government what they had just assisted in what? Overthrowing. Okay? Did y'all hear that? Overthrowing. The Supreme Court is not going to touch that. Okay? What did they overthrow? Let's look at it. Manifestly, when the sovereignty of the crown was thrown off and independent governments established every rule of the common law, including the folk right, and every statute of England obtaining in the colonies in derogation of the principles of which the new government was founded, was abrogated. Did you hear that? Was abrogated. Here comes the prescription of sovereignty that we're talking about, now called eminent domain. All right, that would be Title 20 of a revised statute and the Fifth Amendment of the United States Constitution. The states, for all natural purposes, embraced in the Constitution became one, united under the same sovereign authority and governed by the same laws. That's eminent domain. But they retained their jurisdiction over all persons and things within their territorial limits, except which were surrendered to the general government or restrained by the Constitution. And protection to life, liberty, and property rested primarily with them. So far as the just commune or folk right, right there, y'all. Did y'all see it? So far as the just commune or folk right related to those rights of persons was concerned in the colonies, they regarded it as their birthright and adopted such part of it as they found applicable to their condition. You hear that? You can't touch this with a 10-foot pole. Okay? They became sovereign and independent states, and when the republic was created, each of the 13 states had its own local uses, custom, and common law, while in respect to the national government, there necessarily was no general independent and separate common law of the United States, nor has there ever been. Did y'all hear that? Did y'all hear that? No, you must not. As to the jura corona, including therein the obligation of allegiance, the extent to which these ever were applicable in this country depended on the circumstances. and it was seen quite clear that the rule-making locality of birth, the criterion of citizenship, because creating a permanent tie of allegiance, no more survived the American Revolution than the same rule survived the French Revolution. It's right there. Right there, y'all. Now, why I'm saying all of this? Why am I saying all this? Let's go to the lesson plan. As I come to my closing, all right, let's get it. In the context of the recent Trump versus Barber 2026 oral arguments, the statute of 25th of April III was not a primary focus for the justices because it deals with a separate legal concept than the one at the heart of the current birthright citizenship debate. Did you hear that? So one dealt with just sanguineous, which they not going to touch, and another one dealing with just soil. But Solicitor General is talking about prospective application of the 14th Amendment in regards to just sanguineous, those are born with the parent. So they're not dealing with the retrospective going all the way back to this act because they got no capacity or interest to do that. Okay? Why it wasn't mentioned by the justices, let alone Solicitor General or the opposing counsel? Why wasn't it mentioned? Different legal doctrine. The 1350 Act establishes just sanguineous citizenship by blood parentage for children born abroad. All right? This is not the 19th century. This is the 14th century, and the citizenship dealing with parents was based upon those who were in the church. Okay? Because that's where your ethnicity comes from. God, not people. It comes from God. Okay? The current case is about just soil citizenship by birth on the soil. Just because you're born here does not make you a citizen. Because the 14th Amendment text, all persons born in the United States, is so explicit, the justice focused on the meaning of the jurisdiction rather than on the ancient roots for those born outside of the country, i.e., the English overseas possessions, which means that you're no longer subject to the 1350 Act, but you're subject to Title 8 of the dealing with foreign ambassadors, okay? Foreign children, foreign subjects. All right, let's get it. Settled by prejudice. In 1898 case, one United States versus one Kim Art, the court already thoroughly analyzed the 1350 Act. They concluded that it was a special legislative fix for inheritance, and it did not change the general common law rule that birth on the soil makes one a citizen. Modern justice generally treated that historical debate as settled by one Kim Art. Focus of the 1866 Act. The Solicitor General and the justices, pardon self, the Solicitor General and the Justice spent their time on the Civil Rights Act of 1866. I wonder why. Because it is the American document that allegedly repudiated the old British concept. To the court, the intent of the 14th Amendment framers in 1866 is more legally relevant than the 14th century English statute. I wonder why. Does it still apply today? Meaning de notis ultima re. Technically, the 1350 Act itself does not apply in the United States courts. We're not talking about the United States courts, but it does apply in the state courts because the state has everything to do with the inheritance of property that the states now took it through what they call eminent domain power. Okay, very important. So it might not apply to the United States, but it does in fact apply to the states. Foundation for the modern statute. The idea that children born abroad to United States citizens are also citizens is a principle first seen in the 1350 Act and is now handled by modern federal law, specifically Title 8 of the United States Code, Section 1401. So this is the secularization of that ecclesiastical law or parliamentary law or legislative law to what we call modern law, which is Title 8 of the United States Code. So there is the secular repair. Title 8 United States Code, Section 1401. Used in contrast. In birthright censorship cases, the 1350 Act is still used by lawyers to show that censorship by blood always requires a specific law passed by the government. Who passed the 1350 Act? The government of Parliament. Not no church, not no clergy, but the official in the official capacity who has an interest in the laws governing inheritance in regards to an estate of inheritance, which is called an entail estate, contrast to what we call fee simple estate. All right. So as it said that an act under the 1350 was a special act or specific act that was not a part of the original common law. Okay. Very important to understand that. 3. Historical interpretation. It remains a tool for the originalist scholars to argue whether the United States truly broke away from the English common law or simply adapted it. While the 1350 Act is fascinating historical root, the Supreme Court in Trump versus Barber is far more concerned with whether the 14th Amendment was intended to create a permanent underclass by denying citizenship to children born on United States soil. This is very important to understand the impact that the 1350 Act has in regards to the overseas possessions that were controlled by the English kings that have now been secularized to what we call corporate law under a corporate capacity, okay, which is we're going to talk about right now. The transition is explained. Let's explain it. The specific phrasing is a legal clause found in New Jersey state law, specifically within the statutes governing property tenures. According to the Jersey Revised Statute, Section 4603-2, this language refers to the land holdings established before July 4th, 1776. Okay, we know that prior to July 4th, 1776, they were governed by feudal law going all the way back to William the Conqueror. Okay, because William the Conqueror brought in feudal law. Prior to that, it was governed under what we call folk right, and under folk right transferred to what we call bookland when things became recorded through the county recorder's office, which we know the first county recorder office was who? Frederick Douglass. All right. So this dealt with the land holdings established before July 4th, 1776. So this is pre-revolutionary, which were originally held under the authority of the King of England or other legal, there go that word again, entities like a body of politics or corporate. Okay? Very important. And yes, the King of England is a corporate body. It's an office. All right? Let's look at this in context. Forces going 3-2, all right, which is a statute, a modern statute, i.e., what we call uh, a prospective statute, ensures that the old colonial interest and capacity in land tenures are legally transitioned into a modern form of ownership, which they now call free and common soakage. Okay? They call it free and common soakage, which is another term for what? Allotio. Free and clear. All right? So let's break down the free and common soakage based upon the plain language of what we see in New Jersey Revised Statute 46:3-2. It says King of England, which refers to land originally granted by the British kings or the English kings before the American independence. Okay? That's what it means. Let's go to the statute and look at it for ourselves. certain tingers holdings turn into free and common soakers. So it's operative law. Okay, prospectively, not retrospectively, but prospectively, it is operative. Okay, so this denotes to a interest in property, not capacity to have an interest in property, but a interest in property and the interest that runs with the property pre-revolutionary. Okay, and we know modernly there is no kings. Okay, of England. Okay, all right. It has now been secularized. Okay, into a corporate body or a body of politics. Okay. So that's how you should look at the interest and capacity that was held by a king. And now has been corporatized. Okay? So that now the thing is of honors, manors, and lands, and tenements, or of a hereditaments, or of a state of inheritance at the common law, held either of the King of England or any other person or body of politics or corporate, so that person represents a capacity, all right, that might not be as the King of England. Why? Because now the laws that were made by the King of England have now become secularized into either a body of politics or corporate, still under the person because you need an office, okay? And this is pre-revolutionary because it said at any time before July 4th, 1776, okay? Very important to understand that, all right? Let's go back. Then it says body, politics, or corporate. All right? All these positions or capacities need a person to act in that position or that office. Okay? Whether you're the King of England or you're a body, politic, or corporate, you need people to fit in those positions. When we talk about people, we talk about natural people. Okay? Very, very important to understand that. All right? Okay. Now we read what crown land is. Crown land is a personification of the crown by the monarch. Okay, which is a representation of intel estate that does not depart from the monarch. Okay, hence the word mortmain, dead pledge. All right, let's look at the historical significance. This law, okay, has historical significance. This law effectively served the feudal ties, severed the feudal ties to the British monarchy for New Jersey landholders, confirming they hold their property independently of any formal royal or corporate lord. Did you hear that? The historical significance of New Jersey Revised Statute 1423-2 secularized the law from any feudal lord. Okay? And now barred it or transited to what we call a corporate capacity, not under a corporate lord or a corporate entity acting in the feudal days, but under modern law. It says this lesson plan focuses on the precise moment New Jersey transitioned from a feudal colonial system under the English crown to a secular sovereign state system. Okay? This is a legal framework we're talking about. Let's check it out. The Great Secular Break. Topic: the abolition of feudal tenure and the birth of New Jersey's lordly property right. Objective: you will identify the legal shift from land held under the English authority to land held under the secular state of New Jersey. And when we say New Jersey, this includes all of the United States because the crown controlled all the United States at the time they were considered part of England under the crown in 1702 by Queen Anne. Okay, even though she was a Scottish British queen, she was sitting under the English throne in 1707 because there was no unification with Great Britain until 1707. Okay? But yet we're talking about 1702, and in 1702, we're talking about the English overseas possessions of the kings of England, which was the sovereign authority at that particular time, controlling what we call crown land. Okay? Historical context. In 1702, foundation. Crown's authority, and we know when we say crown authority, we're talking about crown land, and we know crown land represents the capacity interest that runs with the land that can only be uh, used by the king, all right, because he has the capacity. So it says the crown authority explains that, or the queen, which 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 one you choose. It says the crown authority explains that in 1702, the properties of East and West Jersey, these were called your feudal lords, okay, surrendered their right of government to what? Queen Anne as the Queen of England, not the Queen of Scotland, not the Queen of Ireland, not the Queen of Great Britain, or not the Queen of the United Kingdom, but the Queen of England, because there was no unification of Great Britain or the British Crown until 1702. Okay? Feudal tenure. At this time, ownership did not. Come on. This mouse is quick. Okay. Let's start over. All right. The Crown Authority explains that in 1702, the proprietors, East Jersey and West Jersey, surrendered their rights of government to Queen Anne and as the Queen of England. Feudal tenure at this time, ownership didn't exist in a modern sense. All land was held of the king or queen. The monarch was the ultimate, hear that, body of politics. English versus British. Emphasizes that this authority was specifically English. Even after 1707 Union, the legal roots of New Jersey land grants remained tied to the English crown, who had the what? Original jurisdiction. We see it right here in the statute. Let's go back to it. It says King of England. It didn't say Queen of Great Britain, Queen of Britain, or British Queen, or Queen of the United Kingdom. It says the Kingdom of England. Okay, in 1702, because prior to that, it was under the feudal tenure of what we call the Proprietors, George Carteret and John Berkeley. And for that, it's clear. Could we go back one statute? 46.3-1 is going to tell you right here. Feudal tenures were abolished. And this is 2026, 2025. The feudal tenure estates and the instances thereof are taken away, discharged, and abolished from after March 12, 1664. That was the charter that was given to George Carteret and John Berkeley by Duke of York from his father, Charles II, once he was restored to the British monarchy. Excuse me. So we see here in the statute that feudal tenures were abolished from William the Conqueror all the way up to George Carteret and John Berkeley. Then it transitioned to free and common soakage as the King of England, corporate body or politics. Let's say in this King of England or body of politics or person was abolished, and it didn't say that. It just say it went from feudal law to free and common soakage, which is the allodial. That's what it said. Okay? So based upon the plain language of the statute, how the state or the United States is acting is an ultra virus act. How we know that? Let's go back to the lesson plan. Back to lesson plan. So feudal tenure at this time, ownership didn't exist in modern sense. All land was held by the king and queen. The monarch was the ultimate body of politics, English versus British. Emphasized that this authority was specifically English, as we see in the statute. Even after 1707 Union, the legal root of New Jersey land grants remained tied to the English crown original jurisdiction. All right? We know that. We know that, brothers and sisters. The legal conflict. Let's find where the conflict comes in. The gap. Note that while the Declaration of Independence in 1776 broke political ties, the land laws were still technically feudal for nearly 20 years. If you add 20 years to 1776, it will be 1796. Okay? If you add 20 years. This is the residual power. It explains that without a specific statute, property was still technically being held under English royal rules, creating a legal paradox for a new republic. So what did they do? They created a secular term from the religious law that was still in place all the way up till February 18th, 1795. Okay, the king was still in office, i.e., the capacity. When they passed this act, February 18th, 1795, they evicted the king. Okay, or evicted the office of the king. Let's look at it. The act of February 18th, 1795, right here. Right here. You see it? Do y'all see this? February 18th, 1795. Right there. You can't make this up. It's right there. Donald Trump is not talking about this, but how are you going to return the estate? All right? How are you going to heal the land? He don't have the capacity. Nor the Pope has the capacity. You must have the capacity of a corporation. So, i.e., the modern day uh, 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 copy of what we call the king. Okay? A corporate office. Let's go back to the lesson. Hold that. All right, sorry about that. The court study, the Act of February 18th, 1795. That's that statute. The secular term. We're going to analyze the language, the plain language of the statute. What is the plain meaning rule? The plain meaning rule, also known as the literal rule, is one of the three rules of statutory construction to justly apply in English courts. The other two are the mischief rule and the golden rule. Okay? We're going to use the plain meaning rule. The plain meaning rule dictates that the statute ought to be interpreted using the ordinary meaning of the language of that said statute. To not do so will be outside of your authority, i.e., your judges. All right? For you to interpret something other than what the language in the statute says, it could be considered ultra virus because that's not your job. You're not the legislation. Okay? Very important. So the secular term, analyze the language held of the King of England or any other person or body of politics or corporate. Okay? Very important. Secular term. Analyze the language. Held of the King of England or of any other person or body politic or corporate. The key provisions. The act declared that all land were turned into what? Free and common soakage. Okay, very important. The break. Explained that this was a secular act because it replaced the divine right of the monarch with a statutory power of the state legislature. Did you hear that? This was a secular break from ecclesiastical canon law to what we call secular law. Okay? Very important. This is a contradiction to what the president is doing right now based upon secular law. Okay? Because you broke away from the divine right of the monarch and moved to statutory power by the state or United States legislator. So what is Donald Trump doing? All right? These are the acts of the Antichrist. Okay? Or any other person claimed to be the Christ. It's anti-government. Okay? Because as I'm reading here, these laws here are the laws of a government that's religious based. Okay? That's religious based. So now we see the break as a result of the February 18, 1795 Act that made a secular turn from the ecclesiastical route that it was originally on. Okay? There was a break. Let's look at the break even more in depth. Consequence. Because of that secular break, as a result of that statute, all right, that turned everything into free and common soakage overseen by the state over the assumed state sovereign authority, right? So let's look at the capacity of the state under Title 52 in New Jersey. Let's look at their capacity. Seat of the government. This is where the capacity of the state comes from, where they are seated, okay? Wherever your government is seated, that's where the authority comes from, which we know to capacity. But yet they claim to have the interest of a sovereign in regards to the eminent domain power they have, which is the power of a sovereign, which we just called it prescription of sovereignty, or compulsory purchase or acquisition of land. Okay? Acquisition of land. This is the power of what? Eminent domain that's not tied to Title 52, governing the state of New Jersey and its governmental seat. So that act will be considered ultra-virus because it doesn't say a damn thing about your sovereign authority under the eminent domain power of the Title 52. Okay? If you want to play that game. All right? The sovereignty, i.e., the power to regulate the land, comes from Title 52. Okay? But the interest, and that's the interest, okay? The only interest they got in the land is regulatory, not ownership, okay? For ownership, you need a capacity as a sovereign, and that comes under Title 20 of the revised statute, which came Johnny come lately, all right? Right here, Title 20. In the United States level, it's called the Fifth Amendment, the power to take under just compensation. So New Jersey eminent domain deals with acquisition of land by director and division of purchase of property or the board of trustees of the state college. Did you hear that? Director of the division of purchase and property. Okay? Held by a board of trustees of the state college, which is an entity. Okay? This is where the eminent domain power comes from of the state. Right there. Right there. All right? The power of condemnation. But Title 20 is not in Title 52, where the state get the capacity. So for them to claim to have uh, a capacity to regulate property to eminent domain in a court of law, that would be ultra-virus. Why? Because the only capacity that one would have, in lieu of the interest that runs with the land pre-revolutionary, would be a king or some other corporate body or politics or person associated with the church or religion. Okay? Very important. Let's look at it. We see here the consequence of the February 1879 5 Act, all right, was turned or evicted the king, all right. It says now that uh, uh, now the state regulates the property by way of its so-called eminent domain power, okay? Very important to understand that. Discussion. Why English authority matters. Preserving the chain. We discussed why the 1795 Act specifically named the King of England rather than Great Britain. Okay? We just read the Act. Okay? The argument. Because the original grants in 1702 surrenders were made to the English authority, that specific authority had to be named and severed. Part so. The argument, because the original grants and the 1702 surrender were made to the English authority, that specific authority had to be named and severed to ensure nobody, corporate or body politic from old world could ever claim reversionary interest in that land. Okay? So a statute had to be passed. Okay? Summary assessment. Question. Why was the 1795 Act necessary if the Revolutionary War was already won? Answer. The war won the territory, but the 1795 Act won the title. What act? The Act of New Jersey. You just read it. Title 46-3-2. It completed the secular transition by making the state of New Jersey not a person or a king the ultimate legal authority. Did you hear that? Did you hear that? Not under Title 52, but with Title 20. Eminent domain. Okay? That is in fact ultravirus. Let's see why. The perspective that the Act of 1795 is an ultravirus issue and act beyond legal authority is a powerful argument rooted in the distinction between sovereignty and the government. Under this view, the English authority surrendered in 1702 was specific legal trust that a state legislature may not have had the inherited power to unilaterally dissolve. Did you hear that? Let's read it again. It said, under this view, the English authority surrendered in 1702 was a specific legal trust that a state legislature may not have had the inherited power to unilaterally dissolve. The ultravirus argument. Let's look at the argument. The ultravirus argument. To classify the 1795 Act as ultravirus, one generally points to three legal contradictions. Let's look at them. The original trust. Oh my God. The original trust, y'all. In 1702. That's the original trust. Okay? The 1702 surrender was a contract between who? The proprietors and the English crown personally. Okay? We're not talking about a person. We're talking about an entity. We're talking about an office. The English crown called Crown Land. It's an office personified by the king. If that authority was never legally ceded or merged into the state, the New Jersey legislature, as a creation of the state, had no standing to modify a contract involving a separate sovereign called what? The English crown. Did you hear that? Let's look at the contractual infringement. If the 1795 Act unilaterally stripped the King of England of his reversionary interest or specific tenure, it could be seen as a violation of the terms under which the land was originally granted. In legal terms, one party of the state cannot write a law that dissolves the right of another party to the crown without their consent. Did you hear that? Without their consent. But y'all don't hear me. 3. Jurisdictional overreach, which makes it ultravirus. Jurisdictional overreach. Because the 1702 surrender was made to the Queen and her hear that word? Capacity. You hear that word? Not the natural person, but the office she holds. The capacity as the English monarch before 1707 Act of Union. The authority in question was independently a legal entity. The argument is that New Jersey, as a state authority, attempted to regulate an English entity, an English capacity that remained legally distinct and superior to the colonial legislator. Did you hear that? Did y'all hear that? The secular versus the sovereign conflict. From a secular law perspective, the 1795 Act was a necessity of independence. However, from a strict title and tenure perspective, the oath of office claim suggests that the state assumed power that it was never granted. You hear that? It was never granted the power, y'all. It was never granted the power, the capacity, but yet they still claim an interest to regulate property that without the capacity to do so. So the state assumed power, it was never granted. The act was a legislative usurpation of the rights that still technically belong to the original grantor, i.e., the crown. Okay? Any land held under the state authority created by this act remains technically encumbered by the original English authority because the legislature cannot legislatively kill a higher sovereign interest. You hear that? Capacity, interest. Interest, capacity. Title 46, Clause 3-2, interest runs with the land pre-revolutionary. Okay? So the state has no authority because they lack the capacity to dissolve an interest that was pre-revolutionary. Okay? So, in fact, what are the modern implications to that? I know I talk fast, but forgive me. What are the modern implications to that secular turn? This is often where modern land title disputes get complex. If the 1795 Act was ultra virus, then every deed transferred under its authority since then carries what? A fatal flaw. This is why you have title insurance, y'all. This is why you have title insurance. Guess who pays the title insurance for yourself and the one who gave you the loan to purchase the house, i.e., a mortgage loan? How many of you understand that? That was the fatal flaw in the chain of title. It was not an indefeasible title, meaning that it was not clear. It was not a clear, it means that it was a cloudy title. All right? The secular state claimed the land in free and common, but the oath of office argument suggests the land is still legally tied to the 1700 English trust. You hear that? That capacity, that office. Let's get it. The English Trust of 1702, the surrender of the government, and the New Jersey Act of 1795 represents the most significant legal pivot in American property law. If the 1795 Act is viewed as oath of office, it suggests that the state of New Jersey legislatively seized an authority, the English Trust, that it did not actually possess the power to extinguish. The following lesson plan provides a comprehensive briefing on this transition, utilizing case law to highlight the friction between English trust authority and secular state authority. Y'all gonna love this. Y'all gonna love this. Lesson plan: the English trust versus the secular break. I need 5 minutes for that, y'all. Let me make me another cup of coffee. Take a 3 minute How I know all this information? I'm just a man like y'all. Okay, how I know this? How do I know all this information? I'm just a man, just like y'all. Lesson plan: the English trust versus the secular break. The legal chain of command from 1702 surrendered to the 1795 Ultra Vires Act. Here in New Jersey, we know New Jersey was known as the Crown, where it was seated in Perth Amber, where my previous address now, which was an apartment, to my house, which is in Burlington, which is another seat of where the Crown existed. Okay, it was called an intendant court, a moving government. So I'm in both the territories where the Crown of England actually sat, operating in the capacity as the Crown in lieu of my complaint. That's before the appellate court on behalf of returning this estate, i.e., lost estate, back to the true heirs by way of me being head of the what? English trust since 1702 by way of my capacity and interest that runs with the land pre-revolutionary. Under what? 16:1-28. Right state under the charge of Great Britain, saved from repeal, an act to incorporate trustees of religious society for property held in corporation place thereof. That's a statute right here. Corporate capacity. The interest that runs with the land is based upon the capacity that existed after the secularization of the ecclesiastical canon law. That will be the law you have now. So it says the saving of rights under charters granted by Great Britain. This is retrospective law, not prospective law. Okay? Very important. Being section 12 of an act, entitled an act to incorporate, personify, incarnate, whatever word you choose to use, the trustees of a religious society, approved April 9th, 1790, 1875. Once again, April 9th, 1008. Parts of them, I'm reading too fast. Being Section 12 of an act entitled an act to incorporate the trustees of religious society, approved April 9th, 1875, saved from repeal. This section vested what? Property. You hear that? This is key. This section deals with capacity right here. That's capacity. An act to incorporate trustee, that it's a capacity. Okay? Then the interest comes here. This section vested an invested interest in property held under charters of incorporation granted by who? Great Britain and corporations created in place thereof. So now this is what this is shown as secularization, y'all. Secularism is no more under a minor. It now became secularized under your state government, all right, which still is under the capacity as under the king, as we see in 1702. But it somehow had became flipped by way of the secular term, by way of the February 18, 1795 Act that we see in New Jersey Revised Statute 42-2, which now puts the state as the sovereign under an act under Title 20 of the revised statute that's not part of Title 52 where they got the capacity from. That is, in fact, an ultra virus issue. Okay? We must understand. The legal chain of command from 1702 surrender to the 1795 ultra virus break. You hear that? Ultra virus break. Not intravalid, a valid break, but a invalid break. The nature of 1702 English Trust. The surrender on April 17, 1702, the proprietors of East Jersey and West Jersey surrendered their right of government to Queen Anne. We're talking about a body of politics, a corporate body. We see it right there in 16:1-28. Okay. Okay. I don't want to miss nothing. All right, right here. One, the nature of the 1702 English Trust. To surrender on April 17, 1702, the properties of East and West Jersey surrendered their right of government to Queen Anne. The trust distinction. The trust distinction. Legally, the properties did not sell the government; they surrendered it, and they surrendered it in trust to the English crown, not the British crown, as the Union of 1707 had not yet occurred. Did you hear that? So it was an English trust, not a British trust. We must understand that. Reserve rights. The properties specifically retained the land rights, the soil, while the power of the government was transferred to Queen. This created a dual system where the crown held the imperium governance and the properties held the dominion, i.e., property. Okay? What we see based upon New Jersey Revised Statute 4622-1, that feudal relationship, I interest in the capacity that the lords had based upon the grants given by those what we call paramount laws that were feudal in nature. All right, that stopped. Okay, that stopped. So now there's a gap between the interest and capacity of the English kings from 1702 to the time up to what we call the Act of 1795, which is nothing more than a usurpation of what existed before. Okay, this was called the secular break. All right. The secular break. New Jersey legislature passed an act concerning tenures on February 18, 1795. The ultra-virus argument. Lack of standing. The state legislature is a creation of the 1776 revolution. It was not a party to the 1702 contract. Did you hear that? Contract makes law. Okay? Extinguishing the king's interests. Extinguishing the king's interests by declaring all land held of the King of England to be now free and common subjects under the state law, the legislature unilaterally ended the English trust. Did y'all hear that? Did you hear that? The conflict. If a trust is established by a higher sovereign, i.e. the crown, a lower body, the state legislature, cannot legally vote that trust out of existence without the consent of the original grantor or an act of the equivalent sovereign status. You hear that? Y'all didn't hear that. Let's look at it in the case briefing, retrospectively. You hear that word? Retrospective. Not prospective, retrospective. Okay? These cases define how the courts view the transition of English authority to the state, not prospectively, retrospectively. You hear that same terminology from the Solicitor General and that case in the Supreme Court. They argue prospectively and not retrospectively, because if they argue retrospectively, they have to go back to the notice ultimarie, the act passed by Edward III for children born abroad and on English overseas land. Okay, very important. These cases define how the court builds the transition from English authority to the state. Capacity and interest. Okay? Capacity and interest. Retrospective, not prospectively. Martin versus Waddell. Very important case. 1842. Supreme Court ruled that New Jersey took the reins of the government. The prerogatives and legalities of the crown became vested in the state. That's theft, y'all. That's theft right there. In that same case, it said that the land was held in trust for the king. In that same case. I got that here too. I'm not going to pull it up though, but I do have it. 2. Relevance. This case attempted to fix the oath of office issue by arguing that the state inherited the crown's trust obligation. It confirms the 1702 surrender was a transfer of public trust rather than private property. 2. Johnson versus McIntosh. Holdings. Established that the discovery doctrine gave the English crown the ultimate title and that the United States and the states inherited that title. Now you're talking about the British crown because the British crown used the doctrine of discovery, which is called prescription of sovereignty, while the sovereign was already here prior to the doctrine of discovery, or through what we call prescription of sovereignty, through land acquisition or compulsory purchase, now called eminent domain. Okay, so stop lying. Relevance that reinforces the English authority as the original source of all legitimate land titles in New Jersey. Okay, so the English crown, i.e., the crown of England, is not English, is not the British crown or the Irish crown or any other crown for that matter. It's a separate body of politics that was incorporated in the state of New Jersey by way of acts of legislation that were passed retrospectively, which now New Jersey inherited by way of prospective laws passed, i.e. Title 42 is going to do that too. Right there. Case law briefing perspective now. Retrospective versus perspective. How this trust issue impacts modern law and future litigation. Public trust doctrine. Modern New Jersey courts still use the 1702 surrender logic to justify the public trust doctrine, arguing that the states still hold certain lands like beaches and waterways in trust for the people, much as the king did. Title stability. Prospective legal challenges often focuses on whether a state-granted title can truly supersede an original crown grant right if the 1795 Act was an ultra-virus overreach. Okay? That has not been argued, though, the overreach. Okay? Now it's before the Supreme Court, the appellate court, based upon this overreach. Lesson summary. The 1702 surrender created a specific English trust. We know that. The February 18, 1795 Act attempted to secularize and internalize that trust within the state of New Jersey. To argue this was ultra-virus is to claim that the state stole the sovereign authority of the English crown rather than legally inheriting it through the Revolution. In the context of the English Trust of 1702, the secular entity of a corporation sold under New Jersey Revised Statute 61-1-28 serves as the legal bridge that protects original colonial rights from being extinguished by later state statutes. Did you hear that? Did you hear that, y'all? And we just read that. While Title 16 generally governs religious corporations, Section 61-28 is a unique saving clause that explicitly preserves rights held under charters granted by Great Britain, the English authority. We just read it in Justia. Now let's raise this argument in a perspective argument by way of a secular argument. Okay, how can we do that? The secular argument 61-28 acts as a shield. The argument is that New Jersey statute annotated or New Jersey revised statute, whatever one you want to use, functions as a statutory admission by the state that it cannot unilaterally override certain pre-existing corporate authorities, i.e., pre-revolutionary. One, preservation of a crown's grant. The statute states that the rights, powers, and privileges granted by the crown are not affected by the state's own incorporation laws, Title 52 and Title 20. If an act of 1795 was truly ultra-virus, 61-28 Act acts as the secular safety valve that allows an entity to claim its authority still flows from the original 1702 trust rather than from the state of New Jersey. Did you hear that? If the Act of 1795 was truly ultra-virus, 61-28 under the revised statute of New Jersey or statute annotated acts as the secular safety valve that allows an entity, i.e., a corporation, a office, to claim its authorities that still flows from the original 1702 trust rather than from the state of New Jersey. Okay? That will be your corporation soul, known as the king's two bodies. Which brings us to point two. The corporation soul as a body of politics. In English law, the king is the ultimate corporation soul, a single person holding an office that never dies. By incorporating under this specific section, an entity essentially stepping into the shoes of that perpetual office, arguing that its authority is extraterritorial to the secular 1795 legislative break. The saving clause versus the 1795 Act. The 1795 Act tried to internalize all land tenure. However, 61-28 explicitly saves rights granted by the previous sovereign. This creation of legal paradox. The state claims all land is now state governed, yet its own law, 61-28, says crown land corporate rights remain untouched. Did you hear that? It remains untouched. Guess who incorporated under the 61-28? We did. As what? The corporation soul. Because the laws of the king was secularized into corporate laws, a capacity and interest that runs with the land pre-revolutionary. How many of you know that? There are my resources. There are my sources, just there. Not the Bible, just there. Lesson plan for corporation soul and the statutory bridge. Okay, this is where the knights, King, what you call the right knights of the round tables and King Arthur. All right, you remember in Indiana Jones when you have to cross uh, the threshold from one cliff to the other without any bridge. Okay, it's a fictitious bridge or plane that you can't cross. Okay, because there's nothing to transition you there. So there was a legal bridge or a legal gap that was severed. Okay, this statue replaced that bridge. Okay, by a legal fiction. No, how I know it. Let's look at it. English land law. English land law. You can't get no confirmer than this. Where is it at? One second, let me find it. Let me find it. Give me a second. English. English. What was it? English. Man, I'm probably typing the wrong thing. Excuse me. It should be right here. It's not it. Oh, English property law. I think that's it. If this is not it, I'll continue to move on. This might be it. No, this is not it. Where is it at? For the sake of the lesson, I'm going to just move on. I can't find it. Alright, let's go back to where I was. Lesson. Alright. Alright, so to understand how New Jersey 61-28 creates a legal exception to the secular break of 1795, the body of politics. The body politic, the king's true body, explains the concept that the English authority was a corporate office, a corporation. So how many of you understand that? All right. 61-28 represents the king's true body, which is what? A corporate office, a capacity. All right. And the capacity and the inches that run with the capacity on the 61-28, you need Title 46 for that. Because Title 46 deals with the inches that runs with the land, and Title 16 deals with the capacity that originated as a result of the secularization of the English law or English land law. Okay? Very important. Then you got the 1702 transfer when the populace surrendered to Queen Anne, they surrendered to that corporate office, also known as what? The crown. Not the private person. Okay? Very important. Let's analyze New Jersey Body Statute 61-28. It says nothing in this title shall impair or annul any right, power, privilege granted by Great Britain. That's why it's saved from repeal. The legal trap. If the 1795 Act was ultra-virus because it tried to kill Crown's granted trust, then 61-28 is the state's own acknowledgement that it lacks the power to do so for chartered entities. Once again, I repeat. the legal trap, ultra-virus trap. If the 1795 Act was ultra-virus because it tried to kill the Crown's granted trust, then 61-28 is the state's own acknowledgement that it lacks power to do so for the to do so for the charter entities. Okay, that's the reason why in my appeal, the state nor the other defendant, New Jersey Land Title Institute, is the one to argue my capacity under 61-28. They want to go retrospectively to a broader analysis, saying that I'm claiming to be the king of England, that I claim the whole land of New Jersey, being that I'm the king. No, I'm not saying that. I'm saying that I hold the capacity in lieu of that interest that runs with the land that says that the crown, not me, owns the land. Okay, it's a contract agreement that cannot be broke by a party that's not to a party to the contract. So the legal trap is that in 1795, the Act, February 18, 1795 Act, which is 46.3-2, was ultra-virus. Then 61-28 proves that is in fact ultra-virus because it severed an interest and capacity that was there prior to the creation of the state. Okay? You must understand that. Case law briefing, retrospective versus perspective. The court ruled the state inherited the regalities of the crown. So the court ruled that the state inherited the regalities of the crown. Counter argument: if the state only inherited the trust, it cannot abolish it. Martin versus Waddell. A corporation sold under 61-28 remains a beneficiary of that original trust that the 1795 Act could not legally reach, i.e., overreach. Perspective use. In modern litigation, a corporation so argues that it is not a creature of the state, but a creature of the crown, preserved by 61-28. This places the entity outside the reach of a secular statute that relies on the 1795 break. Did you hear that? Did y'all hear that? Majority of y'all not understanding this language. You're not understanding this language. I should get another thumbs up for that one. Can I get another thumbs up for that one? Conclusion. The fatal flaw. If 1795 Act is a secular break, then the 61-28 is a secular repair. It admits that for certain charter bodies, the English authority was never truly ceded to the English. Did you hear that, brothers and sisters? Did you hear that? Let's see. I think I covered everything. So back to this prescription of sovereignty. In closing. Prescription in international law is a sovereignty transfer of a territory by the open encroachment by the new sovereign upon the territory for the prolonged period of time, acting as a sovereign without protest or other contested by the original sovereign, i.e. the crown, i.e. the king. It is analogous into a common law doctrine of easement by prescription. What is it? Said the doctrine legalizes the jure or de facto transfer of sovereignty caused in part by the original sovereign extended negligence and or neglect of the area which is in question. Okay? So there it is. You must understand the capacity and interest that runs with the office that these entities are claiming to have in regards to an estate that was promised to you by an entity known as the church. Okay? When in the state was nowhere in the picture at that particular time. So please honor your ancestors as their ancestors honor you through the law they preserve in lieu of your heritage or estate that left for me to preserve through my incorporation as the king, i.e. the corporation. So, and with that, I greet you as I always greeted you in the name of King Edgar the Peaceful, and not that Jesus Christ, who Donald Trump is posing to be. Okay? So ask yourself, is he in fact the Christ or the Antichrist? Either way, it's going to benefit us. So with that, peace.